fifth story out front. New audio evidence in the killing of Trayvon Martin. Now, we're going to play you the tapes in just a moment. It could be a huge development in terms of an eyewitness and what he saw when the two men were fighting. Now, this comes out just the day after we got those two photos of George Zimmerman. You remember, we showed you this last night. This one, wounds to the back of George Zimmerman's head. This other one that we'll show you is a grainy photo from a phone camera that shows a swollen nose for George Zimmerman. That was taken by a policeman at the scene. An autopsy found a cut on one of Trayvon Martin's fingers and trace amounts of marijuana in his body. Now out front tonight, Bradley Cohen, a defense attorney in Florida, Stacey Honovitz, a Florida state prosecutor, and Jasmine Rand, an attorney for Trayvon Martin's family. Good to have all of you with us. And I want to just begin by playing you a little bit of the audio that we have here. This is a statement that a witness who saw exactly what happened between Trayvon Martin and George Zimmerman, a witness of what he said. Let's play it.
When I first walked out there, the black guy was on top. And the only reason I can tell that was because the guy that was on the ground under him at that point, wrestling, was definitely a lighter color.
Bradley Cohen, how significant is that statement?
I think it's pretty significant. I mean, you have someone who actually saw what happened. Now, what the argument is going to be is what happened prior to that. Who struck who first? Who attacked who first? But in terms of Zimmerman's story, this certainly gives credibility to what he was saying, that Trayvon was on top of him and that he was being assaulted while he was on top of him. But we don't know how that began.
All right, and Jasmine, what's your reaction when you hear that? I mean, is it as damning as it seems it could be?
I mean, I don't think that evidence is really that significant. We've been saying from the very beginning, and the fact still remains, that officers told George Zimmerman not to get out of his car, not to pursue Trayvon. Zimmerman made the decision to get out of his car. He followed Trayvon with a loaded weapon and pursued the teenager throughout the apartment complex. So I think it's very clear who the aggressor in this incident is, and I think that the injuries are very consistent with the evidence. We know we have George Zimmerman with some scratches, and we have Trayvon dead with the use of a gun.
Okay, but we do also have, I mean, those pictures. I mean, George Zimmerman, it was more than scratches. I mean, he had several areas in the back of his head where there's blood pouring off his head and a broken nose.
He certainly did not have any life-threatening injuries. I think most notable, EMT was called out. They told EMT to turn around. He did not go to the emergency room that night. And let's not forget that nobody saw George Zimmerman that night. So no one medically inspected him until the following day. So, you know, the evidence that we have now...
Go ahead, finish your point, and then Bradley, come in.
The evidence that we have now still remains that Zimmerman pursued and shot and killed Trayvon Martin.
Okay, go ahead, Bradley, then I want to get to Stacey.
Sure, Aaron, just because the injuries are not life-threatening doesn't mean that the individual did not feel his life was being threatened at the time he was being beaten. Just because your injuries don't say, oh my God, these injuries look like you could have died from them. If someone is, like he said, was smashing his head against the cement, you'd feel that your life was in danger.
All right, let me, Stacey, play something else we heard today in the discovery, and this is something everybody has been waiting to hear. The first time we've heard the voice of Trayvon Martin's girlfriend. Everyone who's following this case may remember that he was on the phone with her right as this whole altercation began. Her identity still hasn't been revealed, but here's her voice, and here's what she said.
So you definitely could tell another voice that was not Trayvon.
Yeah.
And you heard this other voice say what?
Yeah. What are you doing around here?
What are you doing around here? Okay.
And I called Trayvon. Trayvon, what's going on? What's going on?
This is you saying that. Okay.
Damn. I'm calling him. He didn't answer.
No answer from Trayvon.
Yeah. Just hear, I hear his son like bump. You can hear that Trayvon bump. Somebody bumped Trayvon. And I can hear the grass.
So, Stacey, what do you hear there?
Well, listen, everything we're discussing tonight is extremely significant. We've been waiting to hear if anybody was an ear witness or an eyewitness, and certainly in this discovery that's been disseminated, we're starting to see or feel what actually went on. But without knowing exactly, and because none of these witnesses can tell you who started it, but certainly we know who set the chain of events in motion, and that's what's very important. That Zimmerman was the one that got out of the car and started the chain of events, and certainly we know that the law states if you are the aggressor in all of this, you can't then stand behind the shield and say, I'm standing my ground. putting that aside, none of us on this panel know all of the evidence. The prosecutor does, and now the defense attorney is getting everything. And at the stand your ground hearing, it will be very important for this judge to make the decision by preponderance of the evidence if, in fact, it was more likely than not what Zimmerman said happened. And that's when we're going to know.
Brad, let me ask you a question, though. Let's just say from these two pieces of evidence do end up being directionally what happened. So the first person to step out of the car and cause the problem was George Zimmerman. Does it then matter if he was on the bottom in the fight, if he started it? Does he have any grounds to still use self-defense if he started it?
Well,
Absolutely,
we know
because it's not that he was the starter. He wasn't. Being the aggressor means the physical aggressor. Following someone is not the physical aggressor. Calling someone a name is not the physical aggressor. The first physical aggressor is the individual that can't stand behind the law. We don't know who the first physical aggressor is. Because I walk out of my house and I get hit by a car, is it my fault that I walked out of my house to get hit by the car? No. The fact is the law is very specific in that it's a physicality type law. It is not calling your mom a name that starts as an aggressor.
So, Stacey, then what if we never know who was the first physical aggressor? How does this case then go? What if we never know?
Well, certainly there is more evidence, and probably it's, well, not probably, it's going to be left up to a judge to say, I don't know who started this. I don't know who was the aggressor in all this. I don't know really what happened. It's murky, and that judge, the standard is very low. It's by a preponderance of the evidence, which means it's more likely than not. That judge has to make the decision whether or not he's immune from prosecution or whether or not this is a self-defense argument that has to go to a jury. So it's a murky situation. And now, by just getting these little bits and pieces of the evidence, we don't know the whole picture.
Jasmine, what about the marijuana question? You know, last night we had on a forensic pathologist who was talking about how the sample was taken from what he called so-called open blood. And he said really as a result, the amounts that were shown in the autopsy didn't mean anything, that it could have meant he was smoking right before or smoking hours before. It was just you are unable to tell. How much more difficult is that going to make your side of this case?
Not at all. It has absolutely no legal relevance to the case at hand. And in fact, it's so insubstantial that it's not even admissible in Florida courts. And I want to go back and address that last issue about physical aggression. I think it's physically aggressive to follow somebody with a loaded gun. And when we talk about fear and somebody fearing for their lives, certainly a 17-year-old child who's being approached and followed by a grown man with a loaded gun would certainly fear for his life.
Well, that sounds interesting, but the Florida case law doesn't support that. The Florida case law says very specifically what physical action is, and following someone is not a physical action. It is a physical aggression towards that individual. That's what counts. He didn't even know, allegedly, that Zimmerman had a gun. Zimmerman never said he pulled the gun before the whole altercation occurred, and that's the only person that we can hear at this point. If there's other witnesses that come forward or other statements that are made, that's to be seen.
Well, that's the thing. I mean, right now we're talking in the hypotheticals. We have a couple pieces of evidence, and certainly the prosecutor, before they filed the indictment, the information, had a slew of witness statements and audio and photographs and forensics, and that's what we have to wait and see. To sit here and say that because we don't know if he's the aggressor or this one witness came out after the fact, we don't know how long that witness was watching. This is all for the mini hearing that's going to take place for the Stand Your Ground.
All right, well, thanks very much to all three of you. We appreciate it. All right, when